moment. I want to thank our corporate sponsor, Beverly's and Plimpton, for sponsoring this event and buying you all pizza. I'm Jennifer Rogers. I run the CAPI Center, the Center for the Advancement of Public Integrity here at the law school. If you're all interested in public integrity issues, which I assume you are since we're here to discuss that today, then check us out. We've got lots of pro bono projects, and we're still looking for summer interns if you are GSF funded. Yeah, I don't know. That's better. If you are getting GSF funding and are looking for a slot for the summer. So what we're going to do today, I'll introduce our two distinguished professors who are joining us to talk about some of these issues, and I'll just bounce between them with a number of questions, and we'll leave plenty of time at the end for questions, although, it's fairly formal, so if you have any questions as we go, feel free to raise your hand while we move along. To my left is Richard Briffault. Do you want to keep pizza?
Yes, I'm not proud. I'll eat pizza.
Good. That's going to be, pizza's great. Maybe I should. Professor Briffault is here at Columbia Law School, of course, and he teaches in many areas, many of them relevant to our discussion today, government law and ethics legislation. He's also on our CAPI board and is the chair of New York City's Conflicts of Interest Board, which obviously adjudicates, among other things, conflicts of interest. So he's all set to talk about Trump's conflicts today. And to my right is Professor Jay Wexler from Boston University Law School. Jay is a constitutional law scholar, and he focuses on Constitution, and also religious freedoms, the environment, and he wrote a book about the odd clauses, which really means not weird but unusual, I think. So he's primed to talk about the Foreign Emoluments Clause, which is something that we all learned about fairly recently, but I'm sure Jay's been all over for.
Oh yeah.
Ever since the Constitution was drafted.
I've been following.
He's been working on the Emoluments stuff. Jay also writes the SCOTUS humor blog, which some of you may know. He does things there like adding the laughs that different justices get. And if we have time in the Q&A, maybe someone wants to know about this new nominee. And I don't know if he's funny or not. I mean, maybe we can.
His book about euthanasia is hilarious.
Okay, so I'm going to start with you, Richard, since you've managed to have most of your pizza. Let's start a little bit narrow, since some of these issues just get so confusing. But let's talk about nepotism. That's something that we didn't get to last week. So the facts are fairly simple. The president has appointed his son-in-law to a senior White House advisory position. To some people, that screams nepotism. Can you tell us what nepotism is, why it is that there are regulations about this? Is this appointment a violation of any such regulations, and if so, what can be done about it?
Okay, so nepotism is the practice of hiring your relatives to hold a job. It's actually a practice which is regulated, frowned upon, or forbidden in the private sector as well as in the public sector. It has all sorts of problems. There's a sense that you may be feathering the family's finances by using taxpayer dollars to hiring a relative. Hiring your son-in-law is a good thing that makes your daughter happy. The New York City Board of Elections is famous for its nepotistic practices. That's an aside. People often hire friends and relatives as a way of both adding to their own resources and strengthening, getting taxpayer dollars on their side. It also can be a little demoralizing within the agency. People can get hired and promoted without necessarily the intention to marry. And the person holding the office, the nepotism beneficiary, may often be seen as more powerful and more influential because he or she has the chief's ear than other people in similar positions, or even in that person's nominal superior. So it can be seen as a way of misusing public dollars. It can also be seen as a way of kind of screwing up lines of authority within an agency and can be somewhat demoralizing.
So is this a nepotism against any regulation?
There is a federal statute, 5 U.S. Code 4110, which prohibits certain classes of federal officials from hiring relatives. The relatives defined include specifically sons-in-law in the defined category. Many people see it as something that was adopted in the aftermath of President Kennedy's appointing his brother, Robert Kennedy, the Attorney General. The statute was adopted in 1967, so the timing is not far off. However, there is some uncertainty as to whether it applies to the president because of some technical language in the way it's phrased in terms of referring to executive agencies, whether or not the president is himself an executive agency. And there's also some controversy about whether a later statute, the 1977 Civil Service Reform Act, whether in some provisions of it which basically say none of this here is designed to interfere with the president's power to appoint his own staff, whether that operated as a later amendment. Just recently, right around the time of the inauguration, I forget if it was the day before or the day after, I think it was right before, I'm not sure, the Office of Legal Counsel, which is the in-house office within the Department of Justice, which operates to give advice to the Attorney General, ultimately the President, on legal issues that would affect the presidency, opined that the anti-nepotism ban did not apply to the President's appointment of Jared Kushner to be the special advisor. One thing I should say is that the statute basically said both bans a nepotistic hire and also bans paying the nepotistic beneficiary. I think nepotistic comes out of the Latin for nephew, and traditionally people were appointing their nephews, who might have been their illegitimate children, which is, I think, the origins of the concern about nepotism. Trump is always never going to pay him, and some people thought that was enough to answer it, that technically the statute was applying even if he wasn't being paid. But the OLC opined, and this would have been an OLC appointee from the Obama administration. I don't even think, I'm not sure if the new administration has even made an OLC appointment yet. Certainly it wasn't, it was an Obama person who made the ruling, basically saying that due to the 1978 amendment to the Civil Service Act, that it did not apply to the president in this context. So they have actually gotten a clean bill of health on the hiring of Jared Kushner, and in some ways, it's actually, one might argue it's a good thing. I think he needs it to give him a formal appointment in order to get security clearances. Otherwise, you could say, why isn't he just using as an informal advisor? I think in order to be present at certain meetings, he needs the clearance. It also means that actually ethics rules now apply to him in a way that they might not or would not have if he'd not actually been.
So speaking of OLC, Jay, you actually worked at OLC.
Yeah, right. So I worked at OLC, and I don't know anything about the corrupt nepotism statutes. I did look at the opinion briefly, and it's 15 pages long. It's a classic kind of OLC opinion. The person who signed it was Dan Kofsky, who is a civil servant. He's goes on. I worked there during the Clinton administration, and Kofsky was there then, and he had been there for a long time already. And he was maybe one of the most respected people in the Justice Department. Just has this gigantic brain and knows all the quirky stuff about the executive branch that most people coming in don't know. And I read the opinion, and it looked very much like classic OLC, careful, reasoned analysis. I have no idea if it's right. I have no opinion on that, but I'm pretty confident that if he wrote it, it's at least in the ballpark.
Actually, the kind of interesting sort of spin on this, there were no cases on it. So much of the stuff we're talking about today, there was either no case law or next to no case law. The closest thing to something on this was actually when President Clinton appointed Hillary Clinton to head his healthcare task force back in 1993. The question came up as to whether or not that was subject to the Federal Advisory Committees Act, which is a law that was designed to create transparency for private entities that were created to advise the federal government on policy. Everybody on the President's Healthcare Task Force, I think, was a government employee, with the exception of, Hillary Clinton, who was the First Lady. And the question came up, is the First Lady a public official or not? And then sort of kind of backed into that, does that make it nepotism for the President to appoint her? And in the end, this got to the D.C. Circuit, and then the D.C. Circuit resolved the dilemma of whether or not the First Lady is a public official. If she's not, then the fact of the Federal Advisory Committees Act applies. If she is, then it doesn't. By saying, well, there's an appropriation. The federal budget actually makes an appropriation for the office of First Lady, and that's enough for us to make her into a public official. And then there was a back and forth, in dictum. Judge Silverman said, and by the way, that might raise the question of the anti-nepotism law, and I think it probably can't constitutionally be applied to the president, and that led to a separate opinion by Judge Buckley, who agreed with the holding back and to say, I think you're completely wrong about that, or I think that the question of constitutionality remains open. So we're still kind of interested as to whether or not constitutionally you could apply the anti-nepotism rule to the president. But the OLC opinion is basically based on the 1970 extension.
So Jay, let's talk emoluments.
Let's talk emoluments.
Yeah. Tell us, what does it mean? Has it been used before? Can it be used now at this time?
Yeah, well, so let me read it just in case anybody hasn't memorized it yet. It says, this is Article 1, Section 9, it says, no person holding any office of profit or trust under them, meaning the United States, shall, without the consent of Congress, accept of any present, emolument, office, or title. So that's what the clause says. It clearly was put in the Constitution as an anti-corruption tool to make sure that our officers in the United States are not being subtly influenced by foreign nationals, which was something that was very important to the framers of the Constitution. The Constitution is filled with these kinds of anti-corruption provisions, and it was clear that they wanted to make sure that this kind of corruption that they saw in England was not going to happen here in the United States. The clause has never been interpreted by the Supreme Court or any other court, as far, at least this particular clause has never been interpreted by any court, as far as I know. Office of Legal Counsel has, this executive branch office has a series of opinions about what counts as an emolument, and maybe some things about like who does the clause cover and things like that. They don't really get us anywhere near figuring out whether President Trump has any emolument problems. So where am I?
Well, what does the word emolument even mean?
I don't know. We should go around and have you ever thought of the word emolument before? So there's a difference of opinion. One opinion that's put forward by Larry Tribe and Eisen and Painter in their lawsuit, claiming that Trump's in violation of the Emoluments Clause, is that emolument means something like anything of value, anything of value, very, very broadly defined. There's a counter view which says that emolument is a money that is tied to the performance of an office. So for example, if the French government were to give Donald Trump $50,000 per year for his service as U.S. president, that would be an emolument. But a fair market value transaction involving Trump hotels or Trump wine would not be an emolument. And I think there are a couple of things to say about that. One is, other parts of the Constitution use the word emolument. That it comes up two other times. And in those two other instances, it is fairly clear, I think, that the word emolument is tied to an office. The amount of money that somebody gets directly for serving in the office. On the other side is the language of the Foreign Emoluments Clause, which is so broad. There are 3 any's in it, and then a whatever. So if you haven't ever focused on it, it's it says no person holding any office under them shall, without the consent of Congress, accept of any present emolument, office, or title of any kind, whatever. It's pretty broad. And so there's an argument that even if emolument in the other 2 clauses is more narrow, this one might be read more broadly to encompass everything that we might have even considered to be an emolument back when the Constitution was framed.
So tell us a little bit more about this lawsuit, right? This crew group has sued. Tell us a little bit about the lawsuit, what you think of the lawsuit, what chances does it have, and then later we'll talk about whether there are any other means to try to enforce the Emoluments Clause aside from a suit like this one.
Right. So the crew suit, one of my colleagues at Boston University said that this lawsuit was a great press release, which in some ways is a good way of thinking about it, because it is basically just a general lawsuit claiming that President Trump is in violation of the Emoluments Clause because he has this enormous business network that's all over the world. It's inevitable that any time a foreign state or a foreign state-owned business gives him money, that's an emolument. He's in violation. The reason why that case isn't going to go anywhere, I think, is because the plaintiffs don't have any standing. They're making a generalized complaint about government, a generalized complaint to the president is a violation of some provision of the Constitution, and that there's no direct injury to Crew itself that I think will survive any court's analysis. Now, they have a unique theory in the lawsuit, which is something like, if it wasn't for how Trump's violating the Emoluments Clause, Crew could spend his time suing about other things. So they can't sue about those other things because they have to focus on Trump, and that's an injury, which is clever. And but if that's true, then I think standing pretty much disappears as a check on Article 3 courts hearing cases. Why would, I don't know if you have studied standing, anybody here, but like the Lujan case, think about that case, about the Nile crocodile. I don't know if you know about that. But anyways, why wouldn't the defenders of wildlife have been able to sue directly in that case, claiming, hey, you didn't, well, if an organization has standing simply because there's a law, if it has to bring a lawsuit to stop something, then there's no standing.
What if they, some people have suggested that if they just brought in a competing hotel chain or something like that, saying like, oh, they're all kissing up to the president, and so, they're taking business from us. So that kind of saying, would that cure this problem?
So that would seem to cure the standing problem for the particular case that they bring. So my favorite way of thinking about the Emoluments Clause is with this example. I actually, by the way, think that we should be calling it the Presence Clause. I don't know why we started talking about emoluments instead of presence. Everyone knows what a present is, but imagine this scenario: the Chinese state government is having a big dinner, and they want to have some wine, some champagne or sparkling wine with an appetizer, which happens to be scallops. And so they try to figure out which wines to get, and there are all these great French wines out there. You might have heard of them. But instead, they decided they're going to curry favor with Trump, and they order 100 bottles of Trump's Blanc de Blanc because it has a hair on the nose. You can look this up. It goes for $38 a bottle on here as well with mild cheeses. Anyways, the decision by the Chinese state government to buy 100 or 1,000 bottles of Trump wine instead of, say, Sancerre, right, by X company in France, I think that's a gift, right? Assuming that they could have chosen either, and assuming that the Trump wine may not be as good as a French, I guess Sancerre is not sparkling wine, so champagne, that seems like a present to me. Now, in that case, if you had the French wine company, and they happen to know that they were like the last, on the list. It was down to Trump wine versus, what's a good champagne? Moet, yeah, Moet. And the Moet company knew that the Chinese government bought Trump instead of Moet. Then I suppose Moet could bring a case saying that they were personally injured by this emoluments violation. The remedy, though, I don't know what the remedy for that would be. I guess the remedy would be something about the wine. You pay back Moet for the money they lost. It wouldn't be Trump's not president anymore.
And that's another compromise with the lawsuit, which is that they just ask for completely undefined, injunctive something or other, and it's totally not clear what they want, right?
Yeah, and the idea that a federal court is going to say, Trump's in violation of the Emoluments Clause, dissolve your business now, or something like that, just seems so out of the realm of possibility. I don't know if you agree, but it seems like that lawsuit is not going to achieve its goals unless its goal was to keep this issue in the public sphere and on the front page of the paper, in which case it's doing a good job.
And what are our other options for enforcing this clause? Normally you think of a constitutional violation like this and you think impeachment.
Impeachment!
Yeah, so what about that?
Yeah, that could work. So the House could impeach him for violation of the Emoluments Clause. That seems like high crime or misdemeanor to me. And then the Senate would try him. Now, what's interesting about how if that's the only remedy, and I think it really is the only remedy, then it turns out that these technical questions about what an emolument means, as in 1787 and all that stuff, which is all very interesting to scholars, but none of that really matters if this is a constitutional provision that I think the people are actually going to be interpreting. Right? Since the only remedy is a remedy that comes from the political branches, and the political branches are going to decide whether to impeach somebody based on their view of whether the people who elect them want them to bring these impeachment proceedings. It's really the people who are going to decide whether Trump is in violation of the Emoluments Clause. It's kind of an interesting popular interpretation phenomenon, in my view.
Richard, you want to jump in on Emoluments at all, or should we?
Sure. Just on the meaning, this is actually an interesting one for originalists, I think, because I think the originalist interpretation is very strong that he is in violation. That apparently the term emoluments was actually quite common use in the 18th century. A number of early state constitutions use it. That the state shall not provide any special privileges or emoluments. I think it's in the Massachusetts Constitution, which is the oldest, to any man or set of men. It was sort of any kind of special benefit rather than right. The Trump defense has been more than it means salary. It's an anti-salary supplementation. It clearly was meant to be something far broader than that. Gift, I think, you're right. He gives the present. And the famous anecdote, which is also is the opening story of Zephyr Teachout's book, is when the King of France gave Benjamin Franklin a gilded snuff box, a gilded jewel-encrusted snuff box, while Benjamin Franklin was representing the United States in France, and obviously creating a conflict of interest. Trying to make him more interested in French, potentially more sympathetic to French interests in the course of negotiating U.S.-French relations and to American interests. It also corresponded to all sorts of stories about corruption of the British Parliament in the 18th century, through the Crown's efforts to use its resources to win influence with members of Parliament. So it's clearly, and indeed the real parallel for today is in federal law and virtually every state and local government have gift bans. Bans on gifts from people who do business with the government. Sometimes it's a ban, sometimes it's a $50 or $75 limit, but it's widespread rules that basically say somebody, a government official, cannot receive either any gifts at all or gifts of a certain value or anything of value above a certain relatively modest amount. And these are all seen as basically affecting the willingness of the recipient to have a sense of gratitude or openness or access, not a straight-out trade. A straight-out trade would be a bribe. And even the bribery law applies to the president. But this is designed to sort of get in front of that and to avoid situations in which presidents, and not just presidents, any officers of the United States, are going to be unduly open to, sympathetic towards, give access to the giver. And this particular clause is about foreign donors. Now, particularly if you think about the United States in 1787, where a tiny, physically large, but militarily small, weak country, and the odds are there was a lot of concern about the King of England, the King of Spain, or the King of France having undue influence. So, leaving aside the enforceability of it, which I think is a severe problem, the odds are it was meant to pick up a lot of things. So the Carter one is the straightforward provision of something at market value. The actual renting of a Trump hotel room at market value. But even then, the point is that somebody is choosing the Trump hotel as opposed to another hotel, and so that is of value to the Trump organization, even if the giver is getting something concrete on the market in exchange. So there is, I think, a little bit of a pressure on whether or not something given in exchange for something of value would fall within this. But even then, a lot of ethics rules do apply to doing business with the government, doing a private business with the public official, if you also have business with the government. And that's clearly this, or at least it's potential. There's a story about the government of Bahrain decided to hold its annual National Day celebration in Washington. They had previously booked another hotel. They shifted it over to this one. That's the kind of thing that very arguably in a strong argument sense, probably ought to be considered from an originalist perspective, covered by the Emoluments Clause.
So this activity, the business activity and his benefits from that, we've been talking about in context of violating the Emoluments Clause. It also could, if the conflicts of interest rules that apply to federal officials did apply to the president, would be a violation of those conflicts of interest rules. So can you talk a little bit about what the purpose of these conflicts of interest rules are, why they don't apply to the president, what the problem with that is, and why his tax lawyer's description of what he was going to do doesn't fix the problem or wouldn't fix the problem if the conflicts rules applied to him?
Well, I mean, Trump has famously said that conflicts of interest don't apply to the president. What he means is there's a specific statute, 18 U.S. Code 208, doesn't apply to the president. That's the provision of federal law. That prohibits that makes it a crime for various public officials in the executive branch to engage in an activity to participate in a decision or to make a decision or be involved in the government process in which they also have a particular and substantial financial interest. It's particular and substantial. It has to be distinctive. In other words, it's okay for a member of Congress to vote to cut taxes, even though that member of Congress will directly benefit from the tax cut, because everyone, or many people, will benefit from the tax cut. It's not something that's targeted to that member of Congress. On the other hand, a closer example comes with Congressman Price. If you're actually proposing legislation that will directly benefit a specific company in which you have a major investment, that begins to look like the kind of thing where a public official is going to be participating in decisions in which he or she has a financial stake as well as a public stake. And the concept of conflict of interest gets off the idea that public officials are human beings. They have public duties and obligations, and they also inevitably have private concerns. They have private financial concerns. We don't get at all their private concerns, but we're particularly focused on their private financial concerns because we think that's the sort of thing that's most likely to have a subtle influence on how they exercise their public power. We can prohibit certain kinds of outright misconduct through bribery laws, actually making a decision in exchange for private benefit. But the real concern here is that people are going to be subtly influenced, not even know that they're being influenced by the fact that they own a lot of stock in this company, and they know that this company will be directly affected by the consequence of a certain deal. So what the statute says is you have to, it would be a crime for you to participate in that situation. And there are two solutions. One is recusal. Don't participate, delegate it to someone else. That is considered to be inapplicable to the president, either because it's constitutionally inapplicable, either because Congress can't tell the president you can't participate in something, or because we figured everything in the end comes to the president. So the president effectively can't recuse. I mean, the president in practice can choose to recuse if he or she wants, but in the end, I think that the sense was that Congress can't make the president recuse from the decision, even though it might have benefits for him. Everybody else is subject to this, and typically either they recuse or seeing that they hold a lot that's likely to come up over and over again, like if you're Secretary of State, they arrange their finances before they take the job, and with the help of the Office of Government Ethics, and they begin to unload the positions that would be the source of potential conflict. So Rex Tillerson, the new Secretary of State, I was signed a 47-page single-spaced document with the Office of Government Ethics, going through precisely how he is unloading all of his interests in ExxonMobil and all of his other interests, where they're going, how they're going to be managed, and the restrictions that are placed on him after he leaves office. All designed to avoid both the obligation to recuse and the possible criminality if he didn't recuse. There's a similar one when Hank Paulson became Secretary of the Treasury under Bush. He would, was he Global Sachs? Yeah. Again, an incredibly lengthy and detailed unwinding of his positions. But that's really what, when people have a lot of assets and a lot of interests, that's what you need in order to remove the possibility that their decisions would be colored by the recognition that it's going to impact their personal life.
So one more question about this before we leave this topic, and I'm thinking of you wearing your hat as the chair of the Conflicts of Interest Board, where you are dealing with these issues all the time and what employers are doing. I mean, here's the president, so this law doesn't apply to him. He's doing what he's doing, but what impact do you think that his position on these things may have in the executive branch as a whole? Is there a problem with someone? Is there a tone at the top problem with the president just basically dismissing these conflicts of interest concerns that people are raising? What do you think about that?
Well, I mean, I think your phrase "tone at the top" absolutely picks it up. And for that reason, I have brought with me today. Actually, it was a great statement by Walter Schaub, the director of the U.S. Office of Government Ethics, that really relates to this, because people are saying that it's going to be incredibly hard for Trump to unwind all of his interests. He has a lot of interests. And unlike somebody like Tillerson, whose principal interest was stock in a company, it's relatively easy to sell stock, or to transfer to a blind trust, to have a trustee dispose of the stock. There are tax consequences that actually federal ethics law actually provides for so-called certificates of divestiture, which means that you don't get hit with a capital gains tax for unloading your stock if you're doing it as a result of striking an ethics arrangement with the Office of Government Ethics. So there are downsides to this. Trump's interests are more complicated. In many situations, he is a partner with a lot of his work is in real estate. Real estate is particularly complex. Often it involves people in partnership with other entities, with lenders. A lot of what he does is license his name. If he, in fact, pulls the license of his name, the value of the thing will go down. He may have obligations. He's in contracts with a lot of other people. So he's extremely complicated, and it could be quite costly. So that's a real issue, and there will be costs to him. But as Schaub said, and this is my favorite line in his opinion, I appreciate that divestiture can be costly, but the president-elect, he wrote this on January 11th, when he was the president-elect, would not be alone in making that sacrifice. I've been involved in just about every presidential nomination in the past 10 years. I've also been involved in the ethics review of presidents, vice presidents, and most top White House officials. I've seen the sacrifices that these individuals have had to make. It's important to understand that the president is now entering the world of public service. He's going to be asking his own appointees to make sacrifices. He's going to be asking our men and women in uniform to risk their lives in conflicts around the world. So, no, I don't think divestiture is too high a price to pay to be the president of the United States of America.
Okay, there you go.
That argument just drives me nuts. Not the argument you're responding to, right? That it's going to be costly to become president of the United States. Like, he's not taking over the position of a small town mayor, right? He's taking over the presidency of the United States. He's the most powerful person in the world, arguably, and if he has to take an economic hit for that,
So be it.
that's okay, I think.
So let's shift gears a little bit because you do a lot of religious freedom work, scholarship, I think.
Yeah, sometimes.
Good.
Not very good.
Good. Well, let's see if you can dig something out here. There's a recent announcement that Trump is going to work towards undoing some of the bans on churches that are not-for-profits speaking politically, right? So that got some press recently, trying to undo some of these divisions between church and state, and political speech, obviously, money in politics, big corruption, content. So what are your thoughts about that?
Yeah, well, I've only just started thinking about it, really. The Johnson Amendment basically bars nonprofits, including religious groups, from speaking on politics and backing candidates. And my understanding is that the idea that Trump has is to remove that for all nonprofits, not just for churches and religious groups, which he would have to do that comprehensively. Otherwise, we'd have constitutional problems. I don't think there's a constitutional question, really. I think the ban as it currently is constitutional. I think if it was removed, it would probably also be constitutional. So it's a policy choice, I think. And I'm a pro-religious freedom person, even though, and so I get in fights with people on the left sometimes about that, Hobby Lobby, for example, sometimes. So I don't know, I mean, do I think it would be a terrible thing if churches can speak about politics? I don't really think so. Like, it's not the thing that really bothers me about churches taking kids. I'm not gonna throw a party about it, but I don't know. I'm just thinking about it, so I don't have very well thought of opinions.
Okay, great. Well, maybe since you know a lot.
Yeah.
So Richard, let's talk about, you mentioned the OGE, the head of OGE, and what's
Office of
going
Government
on.
Ethics.
Office of Government Ethics. There's also the OCE, the
Office of Congressional Ethics.
And both of them have been in the news lately. The Office of Congressional Ethics went through a tough time a couple days after inauguration when the House Republicans tried to shut it down. It's an independent investigatory body that looks into misconduct by members of the House. And they tried to, well, not get rid of it, but bring it under House supervision, which takes away its independence. And we know that Trump tweeted out something to the effect of, yeah, they're unfair, but don't you have better things to do in the first couple of days? And so that plan went away. And then the director of the Office of Governmental Ethics came under attack for his series of tweets about Trump's divestiture plans or non-plans and so on. So what do these attacks on these bodies tell you? Are we edging toward a problem where we have these independent offices potentially losing their ability to do this kind of regulation? What do you make of this?
It's a good question, and actually there's a kind of a deeper problem here, which is in the U.S. basically we're kind of political all the way down. Now, unlike some other countries where there is a strong tradition of truly independent civil service, where there can be people appointed for long periods of time that aren't accountable to the term of administrations, a lot of things, most everything here that affects the political process itself falls within the political process. As we saw the last go round, our elections are generally run by political administrators, whether they are elected to run the elections, as they are in many states, or they are appointed by political people and serve at the pleasure of political appointees. So it's very hard to come up with institutions that can kind of oversee or oversee the political process and enforce kind of rules of fair governance that are not enmeshed in politics itself. We have tried, and I think these offices reflect different efforts on the part of the government at different times to create sort of quasi-autonomous entities to oversee police. When the entities, the police entity realizes we can't be trusted to police ourselves. So legislatures are particularly difficult for this because legislatures don't want to subject themselves to executive branch controlled law enforcement or to judicial controlled law enforcement. And this goes back to the Parliament and their fights with the Crown in the 17th century. We have a speech or debate clause in our federal Constitution, which is designed to create some immunity for the Congress, and virtually every state has its equivalent. So there's a lot of nervousness about applying traditional law enforcement to members of Congress. So what are the three mechanisms for policing ethics in a place like Congress? Traditional law enforcement, which they're really nervous about, and there's a constitutional yellow light, if not a red light. Elections, let the voters toss the bums out, but the voters sometimes like the bums. The voters sometimes think that these bums are actually closer to what the voters want politically than somebody else. And self-policing. It's really hard to police yourself. And so what you get in some of these entities is an effort to try and improve self-policing by creating, it's like putting kind of a lock on the refrigerator and stop yourself from eating during the middle of the night, but knowing that the key to the lock is still on a cupboard up above. And maybe you can slow yourself down. And that's what this is. The Office of Congressional Ethics was created in response to the last round of congressional scandals which occurred in the mid-2000s. The 2005, 6, 7, 8 period, which actually helped knock out a Republican control. Then a number of people were indicted, went to prison. And so, yeah, the idea was to say, to leave in place the ultimate decision of whether to bring internal charges, not criminal charges, but things like reprimand or expulsion to the relevant congressional committee, but to separate out the investigatory function so that you at least have independent investigators in which the congressional ethics committee has to respond. And that's what the Republicans in the House felt was they bring in a lot of cases. It's really kind of annoying. They may not have subpoena power, but they're really browbeating third-party witnesses. At least those were the claims. So the Republicans, they rather said, let's put this thing directly in the control of our committee, and that's what the revolt was against. The Office of Government Ethics is actually much weaker in that sense, and it has no enforcement power. It was created, again, in sort of a number of things were done in the 70s, in the aftermath of Watergate. It's not that related, but designed to, in some sense, raise the status of ethics in the federal government. It's primarily an educational and advice-giving body, but one of the key things it does is actually, with senior appointees like this, help in some sense get them out of trouble or prevent them from by bringing out these arrangements. But they're not an enforcement body. So, the head of it is appointed as a fixed term, and it's designed to be slightly out of sync with the president. So, although I suspect that the current head of that office has about 11 more months in that position, but I think actually it's term limited, so I don't think he could be renewed anyway.
All right, so let's, I'm going to ask you one more question before we open it up for questions, and it's sort of related, sort of unrelated, but it's about OLC again. So I read in the papers, you obviously can't trust everything you read in the papers, but I read in the papers that the OLC review for form and legality, that the legality portion of that is limited to the legality of whether the president has, in theory, the power to do what it is he's purporting to do, and not a full scrub of whether the executive order is or isn't constitutional or isn't illegal. And so in the context of this immigration ban, this is what I read. The OLC opinion talked about whether the review goes to whether the president's executive authority extends to ordering that sort of thing and not to whether the thing that he ordered is actually legal. But then you suggested to me that no, the OLC legality review is more fulsome than that, and so I'm wondering if you can shed some light for us who are following very closely the now case that we have out in Washington and then
Right.
the Ninth Circuit, what we can expect from those things.
Well, I can only speak to what I saw when I was at the Office of Legal Counsel in the Clinton administration. And I know that in that administration it was similar to what it had been before. So speaking to that, I can say that all executive orders and proclamations that come from the White House are vetted really carefully by not just the Office of Legal Counsel, but any interested agency in the government, other offices in the Justice Department, what other agencies might be related to the order. But OLC specifically is charged by regulation to review the order for form and legality, and at least when I was there, that meant everything. You certainly, yes, you have to determine whether there's constitutional or statutory basis for the president's action. That's the first thing, and that can sometimes be a big mess, right? Especially if there's some sort of implied constitutional power that the president is claiming. But I would certainly have thought that equal protection, First Amendment, free exercise, establishment clause, all those things would have been considered in a typical regular timeline sort of executive order review by the Office of Legal Counsel. We have no idea what happened here. I guess they did review it. They wrote something that said this is approved for form and legality. There's nothing weird about that. I think that that's what we did in the Clinton administration too, which doesn't mean that there isn't a lot of thought behind that one sentence. It's just that it's not always written down. In fact, it's usually not written down. So there's a lot of analysis that goes in, and then it doesn't show through in anything written. So just the fact that there's nothing written is no evidence that it wasn't seriously considered. We just don't know what happened there. We'll see who looked at it and for how long. And there's also, what's happened in the Bush administration is it's sort of a split between the White House counsel's office and the Office of Legal Counsel, where some kind of really sensitive things were sent to the White House counsel and not to the Office of Legal Counsel. Who knows if things like that are happening? We don't know yet.
All right, well, let's take some questions. There's lots to talk about. Yeah.
Yeah, so I'm interested in a couple of issues if you touch on both of them if you would like to. First, the tax returns. What can we actually learn from the president's tax returns? And secondly, what happened to the Golden Dossier on January 28th? The Steele dossier of conflicts of interest, Russia, etc. Where did that go? Because I haven't read anything, I haven't seen anything about it since the inauguration. So is it being investigated quietly? Did it just go away? Did the president tell the FBI to stop? Do we know what happened?
I can answer the first question, but not the second, because I don't know the answer to the second. On the tax returns, first of all, there is actually no law requiring the president to disclose a tax return. That's being proposed by Democrats in Congress. The president is subject to the federal ethics disclosure requirements. So the president is not subject to the investiture requirement or the avoidance of a conflict of recusal requirement, but he must disclose. I think his disclosure will not be due until May of 2018. I think it kicks in at a certain point into the term, and then it's due a year later. So I think the president's disclosure form won't be available until May of 2018. What you would learn is who's paying your money. Would you look at your own tax? Well, your tax return might be really simple. I don't mind this. But you would learn what are his sources of income, and that would tell you is he being Is he receiving, what are his investments? We don't have he's given at various times different lists of investments, so we don't know what all of his investments are. We don't know where they all are. We don't know what, in terms of what countries they're in. We don't know what lines of business he's in, so that if he's promulgating regulations or blocking regulations that affect that line of business, whether one might want to argue that there's a link. Again, all this stuff, this disclosure stuff, is all about heightening our antennae. It doesn't tell us anything, it doesn't give us motives or reasons, but it gives us things to investigate. I mean, that's in some sense, again, one of the big moves in public regulation really going into the 70s is transparency. I think it wasn't actually called transparency then, but as a form of regulation, as a way of making public various things, and then allowing other people, the media, now these days increasingly individuals, to investigate and see if there's anything funny there, and even if there's nothing illegal, to spark a public conversation. And is it relevant? It is. I don't think I'd like to have my tax return out there. Not that there's anything interesting in it, but it is an invasion of privacy. But it does go to, in some sense, we invade more the higher up, the higher up and the more central the person is. Tax returns normally are protected, but I think there's a trade-off here, and that we as a community of citizens have an interest in knowing something about the influences that are on our senior public officials. But I don't know what's going on with it at all.
Neither do I.
Yeah, I mean, and we won't, right? It's not uncommon that FBI investigations tend to be closely held until there's a charge to be made, or in very, very rare occasions, a charge not to be made if they decide to go public. So, you know, this is one of those situations where you have to hope that the FBI is investigating something if there is something worth investigating, and if there's something there, we'll hear about it eventually, but it's not uncommon not to hear, obviously, as investigations going on. Yeah.
So, Betsy DeVos was just confirmed as the Secretary of Education. Is it a issue of campaign ethics if it is proven that the families, the $200 billion is a substantial amount, was bundled by them or given to them to the Trump campaign?
Probably not. I mean, we have a long tradition of public officials rewarding their supporters with appointments. It could go to the merits of whether or not the person ought to be confirmed. Obviously, that's now been resolved as to, to the extent that we think the Senate is supposed to be making an appraisal of the qualifications of the person for the position. But we have a long tradition. I mean, certainly lots of ambassadors kind of pointed that way. Every now and then one of the ambassadors is blocked because the person turns up to know nothing about the country. But I don't, unless there's a more concrete evidence of a quid pro quo, unless there's something pretty darn close to a wire that says, here's $100 billion, and I would like to be Secretary of Education or Ambassador to St. James. I think it's politics. And I think there's a kind of a meme out there of people who are skeptical of a lot of these ethics rules called the criminalization of politics. And that some politics we have to accept. And what's acceptable politics evolves over time. But my guess is that given our political practices, even if it were true that she was a big bundler, period. Because, and again, people give a lot of money because they also support the ideology. It's not just about self-interest. They support the ideology of the candidate, but it's not surprising when candidates, when elected, reward their backers.
Yeah.
How robust would you characterize the disclosure process right now for heads of executive agencies, like in terms of the information that's required to be disclosed, and then also as citizens, sort of the accessibility of those documents?
Uneven. I mean, it was interesting. I hadn't fully grasped this until the most recent round. Is that apparently each Senate committee has its own rules about what they require. So this process, traditionally, this process really had two steps. The White House, or in this case, I guess the President-elect's office, would do an ethics screen of candidates before they're nominated, which would include working with the Office of Governmental Ethics. And then there'd be a second round all over again with the relevant Senate committee or committees. Some officials get screened by more than one committee. People in health, for example, may be reviewed both by health, education, and labor and pensions committee, and also by finance, because so much of what they do implicates finance. And then so these committees would often have their own very intrusive and detailed set of forms, some of which they would make public, or in redacted versions. It might not have the dollar amounts, it might have the sources. It turns out they're all very uneven, and the different committees are more intrusive. It also turns out, as we learned very recently, committee rules can be waived. And that practices of pre-submission of candidates for review can be skipped. So a lot of this is in the domain of practice. And I think, this as in other things, the new administration is disruptive. And I think a set of practices emerged in the post-Watergate period, sort of beginning with Jimmy Carter. And running with both Democratic and Republican administrations, Carter, Reagan, Bush, Clinton, Bush, Obama, pretty consistent. We could have debates about individuals in any one of them, but I think they were pretty consistent in following these practices. The new administration seems less interested in following these practices.
So on the presence clause, the emoluments clause, where the champagne clause. Is there, what you said, Jay, I'm just curious, is it only through the outrage of the people in pressuring their elected representatives that you could actually have a conversation or a debate about impeachment? So it wouldn't be through some...
I think that's right, yeah. I think that impeachment in this particular situation would be I like that, it would be a public conversation between the representatives and the people they represent and the executive branch, and maybe he does something, right? And it's very clear that it's what he did. Like right now, everything's kind of foggy. We don't know that. Let's say something happens actually, and the steak dinner, whatever, it becomes public. Then we have to have the discussion about, is that a violation of the Constitution? Because the courts aren't probably going to consider it. We have to think about that as a society. And we often think about whether we think that is a violation of the Constitution. Representatives have to think about whether they think it's a violation of the Constitution. And part of that analysis will have to do whether they think their constituents think it's a violation of the Constitution. So we can have this discourse, in meeting halls and newspapers and the internet, et cetera, to try to figure out what we think the Constitution prohibits. And maybe we'll come to a solution, or at least a decision on a particular thing that maybe he does that is or is not a violation of the Constitution, that impeachment will or will not go forward.
And it would have to come from the majority party then, for it to
Yeah.
go to a...
So, two wrinkles on that. One is, of course, the Emoluments Clause allows the emolument if Congress consents to it. So it is possible that, just as people have talked about, it didn't happen with President Obama giving pardons to various people as he was walking, he gave a lot of pardons, but not political pardons, as he was walking out the door. Should this become, should the tension level on this rise, it is possible that the consent of Congress could be sought, and maybe the current Congress obtained, at least for some things. Obviously not for outright bribe, but maybe for allowing the Trump enterprises to do business with foreign countries. And so you can imagine that. The other question, of course, would be, even taking the emolument is not a high crime misdemeanor. Taking the emolument, unless you can prove that something came from it. I don't know. I mean, obviously it has never, ever come up as to whether or not simply accepting an emolument would be an impeachable offense. It might violate the Constitution, but I don't know that everything that violates the Constitution is an impeachable offense.
Right, that's another part of the conversation.
I saw someone say that maybe, if Trump were to do something outrageous that was not technically an impeachable offense, that this could kind of be there in the background, right? Like you have this emoluments violation that if he does something else that's not a constitutional violation, might then kind of make a groundswell for actually going after impeachment on this ground.
What if he tweets two wrongs make a right?
I mean, obviously, if if either House of Congress changes in 2018, it doesn't look likely, but you never know. We're only a couple of weeks into the current year. This certainly would be a fertile ground for recent investigation. They could do like 8 committees on Benghazi, and if they could have endless investigations of the emails, you could have a lot of public hearings on this. Now, admittedly, there are questions about what I think emoluments is broader than just a paycheck, but how broad is it? And these market exchanges get counted, and who counts as foreign? In one of these cases are probably state enterprises do, but you have to actually spend some time. Oddly enough, it will be a field day for the professors as much as anything else. So we're for it. But I think figuring out what it is exactly would take some time.
Is this actually the sort of thing, it's not an executive order, is this the sort of thing that OLC gets involved in? And would he ask for a legal opinion on this sort of thing, or no? Is that a White House counsel issue?
Presidents have asked OLC numerous times about the Emoluments Clause. There's an opinion from Obama about whether accepting the Nobel Peace Prize was an emolument, and OLC said no because the whoever awards it is a private entity. So it would certainly be within precedent for a president to ask Office of Legal Counsel their opinion about whether something violates the Emoluments Clause. But oftentimes, if somebody doesn't want to know the answer is to a question, they're not going to ask for the OLC's opinion on it.
Right. Okay, maybe one more? Yeah.
Yeah, I was just curious on the emoluments lawsuit. I've heard a structural counterargument that it being in Article 1 means it might not apply to the executive branch. You thought that was legitimate at all?
Yeah, I've heard that. I don't know. There's a lot of conversation also about what officer of the United States means, and there's a scholar who's parsed the use of the word officer in the Constitution and has constructed a incredibly creative argument that the president is not an officer under the United States. So it's plausible, but most scholars don't buy that, either of those arguments. And the Trump administration has not taken the position that the president is not subject to the Emoluments Clause. So far, it's an academic question, but a tricky one, a hard one, I think.
It's even, the argument is even weirder than that. The distinction between officer and office also turns up. People who do this really get into it. And so there's an extended debate as to whether what officer means, but also what is an office of profit and trust under the United States, which is what the Constitution says, or under them, the United States. Is the president an office of profit and trust under the United States, or under the Constitution? Which I don't quite get the distinction, but a lot of ink has been spilled on this. So yeah.
If he's right though that the president is not subject to the Foreign Emoluments Clause, it's also not subject to the Incompatibility Clause, which means that the president can also be a member of the Senate at the same time, which is weird.
Yeah, and there are a lot of opinions. There's other emoluments that they gave an opinion on whether or not there's also a ban on the president making emoluments in states. And so there's an opinion allowing Ronald Reagan to take his pension, because Ronald Reagan was the governor of California and got a state pension. And the question is whether or not that was a forbidden emolument from the state of California. So that's a different emoluments clause. Jay mentioned there are 3. That one is also a different part.
All right, well, thanks for coming, and please join me in thanking